Court will call 2018-349, State of Arkansas versus Ryan Anderson. Mr. Anderson, have you made any arrangements to be represented by an attorney?
I was told I'd be represented by Andrew Bailey, sir.
You know, we don't have an application. I saw Mr. Anderson at the jail. I'm confident that when he fills out an application that the court will appoint us.
Okay.
We have in the past.
Well, what I'm ordering you is, in order to secure that public defender representation, you need to fill out an application. Those applications are there at the jail. Get one, fill it out, sign it, and turn it in.
Yes, sir.
In the meantime, Mr. Cooper from the Public Defender's Office is here today, and advises that I believe he's who told you that Mr. Bailey would be the attorney. All right. You're for arraignment today on charges of domestic battery in the second degree. That's a Class B felony with aggravating circumstances. And then there's violation of a no contact order, which is a Class A misdemeanor. On those allegations, how do you now plead?
Your Honor, he enters a plea of not guilty to all charges.
All right. This case will be assigned to the Division III docket of Judge Putman. I'm directing that you'll reappear in front of Judge Putman on August 23rd. And at this time, you may be excused.
Thank you, Your Honor.
2018-342, State of Arkansas versus Tyler Rivera. Mr. Rivera, you're appearing for the purpose of arraignment on charges of theft of property, a firearm, which is a D felony, theft of property, second count of that, D felony firearm theft, breaking or entering a D felony, and theft of property, a misdemeanor theft. All of those charges, on all of those charges, you're for arraignment today. Have you made any arrangements to be represented by an attorney?
Yes, sir. I filled out an application. There's some type of confusion as to whether it's been responded to or not, but I've been checking in.
When did you fill out that application?
A couple weeks ago. Last time I called, they said that there was one form there and one form wasn't, or I'm not sure. I probably just end up filling out another one and sending it in.
You know, I think he has district court charges also. I think he's applying to district court. We've not received an application for his cases.
All right. Yes, I'm going to recommend that you do that. Fill out an application specifically for this circuit court case, one application doesn't cover all the places you have charges in, so you'll need one for each set of charges. Court's going to note that you're applying to the Public Defender's Office. On the charges I read off, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. Your case is on the Division IV docket of this court. It's being set by scheduling order for your reappearance on November 15th, 2018, followed by a February 21st of 2019 pretrial date, a March 21st, 2019 appearance, which is a plea deadline, and then it's set for trial during the week of March 25th of 2019. Bond has been set in your case at $7,500. Cash or professional bond. All right?
Thank you.
You may be excused. (2018-350) State of Arkansas versus Crystal Morris. Ms. Morris, you're appearing this morning before the court on charges of possession of a controlled substance, methamphetamine, a Class D felony, possession of drug paraphernalia related to methamphetamine, that's also a Class D felony. Before I ask you how you plead on those charges, have you made any arrangements to be represented by an attorney?
I filled out a form for the public defender.
Okay, when did you do that?
They just gave it to me last night, and I filled it out and I gave it back to them last night.
Okay. So you filled out the form, but it apparently hasn't got into the hands of the public defender's office as of yet. This case is assigned to the Division 4 docket, which is my docket. On the charges that I read off, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. In all probability, once that application has made it through and gets reviewed, the public defender's office will be appointed to represent you, and so we're going to go forward at this point. I've entered a plea of not guilty on your behalf. This case is going to be set down by scheduling order. Your next appearance date on this charge will be November 15th of this year. We're going to go ahead and set the matter for trial out in the week of March 25th. It'll be set for a plea deadline of March 21st, and it'll be set for pretrial on February 21st. All of those will be dates that'll be in a scheduling order, but the one that's crucial to you at this point is you understand that you have, if you bond out, you are to reappear on November 15th. That scheduling order also will order you to reappear, also will order you to get in touch and stay in touch with your attorney.
Yes, sir.
What that means is that you are ordered to communicate with your attorney. The public defender's office have so many clients appointed to them that they don't have time to track you down. So you're going to have to, if you bond out, one of the first things you should do is you should get in and see the public defender who's been appointed to your case. You call the public defender's office and make an appointment and get in to see him. He'll then make the arrangements to get the information for your case and proceed to represent you. So that's an order of this court that you get in touch with him. Do you understand that?
Yes, sir.
All right. If you continue to be in jail, I'm confident the public defender's office will contact you there. But all right.
Sir, do I have a bond then now?
That's what I was just going to look for.
It was $2,500, but they had a hold on me because I had to see you, so I didn't know if it's been lifted now or not.
Who has a hold on you?
It was my parole officer, but he said he was gonna have that dropped after I seen you.
Okay, so you've already talked to him?
Yes, sir.
Well, that is the bond, $2,500, cash or professional bond. All
So
right.
the hold's been lifted then?
No, I don't lift the hold.
Okay.
That's the
I didn't
probation. If he's good to what he said to you, then it'll be lifted. But I don't have any control over parole, so you may be excused.
Thank you, sir.
(2018-51), State of Arkansas versus Corey Stone. Mr. Stone, you appear today for arraignment on charges of possession of firearm by a certain person, a Class D felony, and no liability insurance. before I ask you a plea on that, have you made any arrangements to be represented by an attorney?
I haven't yet, sir. I was waiting on to get my probation officer to lift the hold on me so I can bail out first.
Well, what you've got is a new charge. I'm sure that's also part of the basis of the probation hold. Is it your intention to hire private counsel, or is it your intention to apply to the public defender's office?
I was going to try to talk to my family lawyer first to see what he suggests.
Okay. Is that a local person?
No, I'm not local from here. I'm an hour away from here,
Okay.
Minnesota County. The main thing is I had no idea there was a gun in the truck.
On the charges that I read off, that is a possession of a firearm by a certain person and no liability insurance, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. You need to make a decision on how you're going to acquire representation of counsel. What is the bond on this case? Bond is set at $2,500. That's cash or professional. With a 10% posting, you can essentially make a bond on that. That's about as low as I generally set bonds in somebody, particularly somebody who's not local. And on that basis, I'm going to leave it there at $2,500. You're on the docket of Judge Putman, and I will set you for a reappearance in front of Judge Putman on August 23rd. If you make bond and get out, you will be obligated to appear back here on August 23rd in front of Judge Putman at 9 in the morning. If you do not bond out, of course, you'll be available to appear before Judge Putman. Do you have any questions?
So I can bond out now?
You can bond out.
He may have a hold.
Oh, that's right. I forgot, but he mentioned the probation hold.
That probation hold is out of Izard County, Your Honor.
Izard County, okay. Well, we've set the bond low enough that I guess you need, if Izard County is gonna put that hold on you, I don't have any authority over Izard County. They're gonna have to contact you. So you'll have to get hold of your probation officer and see about making arrangements to have that hold lifted or a new charge set of some kind. So
Okay,
that's where you are. All right, you may be excused.
thank you.
(2018-341), State of Arkansas versus Glenn Cockrum. Mr. Cockrum, have you made any arrangements to be represented by an attorney?
No, sir. I haven't been able to get a hold of anybody. My phone's not in property. I don't have any numbers. I don't even have any recollection of even coming here. I just woke up here 3 days later and I was in holding. And like I said, it's been a big blur for 3 or 4 days prior to coming here. I'm not even sure what happened.
Okay. Well, let me see if the
I know I came into town. I was dropping a load, 18-wheeler. My truck broke down, and it just everything just accumulated and high stress. And then my dad loaned me his truck, and then
Can I say something, Judge? If he's going to apply for us, I'm going to advise him not to make any more statements on the record.
all right.
I know he has not done so yet, and Mr. Cockrum, you may not, but I don't think you're helping yourself by making any more statements, okay?
Yes, sir. I'm trying to understand myself what is going on here because my dad loaned me the truck. The next thing you know, I'm sitting in jail.
Okay.
I know the time I left Clinton to here is a big blur. It's crazy.
Well, court has been reviewing the affidavit and that led to these charges. The court will advise you that you are charged with theft of property, a Class D felony, a separate count of theft of property, and then first-degree assault on a family or household member. That's a Class A misdemeanor. So those are the charges against you. What the court's going to advise you is these are serious charges, including 2 counts of felony theft, and the court would advise you that it's in your best interest to get yourself represented by an attorney. And it's all the more important if you don't recall what happened, so the person you need to be talking to is your defense attorney and getting advice on how to proceed. The court can't give you legal advice of that nature, and I'm sure you're not going to get any help from the prosecutor's office because they're on the other side of this case. So the best thing you can do is fill out an application to the public defender's office if you cannot afford an attorney. If you're in a position to afford an attorney, then I would strongly recommend that you hire the attorney of your choice and get that person working on the case. It is your constitutional right to have an attorney, but those are your 2 options. Either hire a private attorney. The court doesn't get involved in that. That's up to you to work out an arrangement with the attorney. But if you cannot afford to hire an attorney, you're still entitled to an attorney, and the way you secure that attorney is you fill out the application. They're there at the jail. They can get a copy of the application. You fill it out, sign it, and turn it in, and it'll get into the hands of the public defender's office, who will then make arrangements to have it reviewed and signed by a judge, and then on the basis of that, they will begin representation of you. So that's your choices on an attorney. The court is, at this point, you're indicating you haven't spoken to an attorney, that you have no idea what went on. I'm going to enter a plea of not guilty on your behalf. You've already said you don't know what went on or how you got here. So I'm going to enter a plea of not guilty on your behalf here in court and set this matter for reappearance in front of Judge Putman. He's the judge who's been assigned to handle your case. Order you for appearance in front of Judge Putman on August 23rd. That's a week from today. And that's where this matter will stand.
Hey, Your Honor, can I get a bond reduction? I've got the money to get out. I haven't been able to get a hold of my broker. He's in Chicago. And like all my numbers, I got to get to my numbers in order to do this. Like I said, I'm a truck driver. I make $80,000 a year, and this is not me. I don't understand what happened. I know my truck broke down, but we can leave it at that. But I got to be able to get a hold of my broker to get more money. And you guys had me set at $10,000, and
bond is set at $10,000. You don't reside here locally. I understand you reside in Van Buren County.
Yes, sir.
And from reading the affidavit, it indicated there is somebody there in Van Buren County who claims to be, if not related to you, at least have an interest in you. And she apparently, exercised some rights on your behalf with regard to the residence that was involved. So I don't know if that's who you need to get a hold of and get that person making arrangements for you. So if you're going to go ahead and hire counsel, basically basically, under the circumstances of this case and the kind of allegations that are made, the $10,000 bond seems very reasonable to this court. I didn't set it, but that's what seems reasonable to this court. Based on what I know about you and your situation at this time. So that's where we are. And I'm not going to reduce the bond at this time. I will direct the sheriff's office to allow Mr. Cochran to make some arrangements by telephone to contact an attorney or contact the person at his residence to help have that person get busy helping him secure an attorney.
Okay, I don't know how else to go about this. Is there a way I can get a medical evaluation, maybe see if my thyroid's act up like my father's and my aunt's and everybody else's in my family, whenever it goes under high stress levels?
Well, that's what why you need an attorney is the attorney to propose that and make arrangements for you. So,
I'm having
I mean,
really
I don't know. I'm not going to just automatically order a medical evaluation. But if you're having medical problems, you're entitled to medical care while you're in jail, and you can talk to the nurse who's in charge of making sure your medical safety while you're in jail. But basically, what you're looking for is what you need is to be represented by an attorney. That's what I'm telling you. All right.
Yes,
All right.
sir. I'm just not gonna be able to afford it if I'm sitting in here. My career's gone down the drain my whole life right now. So it's just really turned. It's like, I'm not a drug addict. I'm not a criminal. I work hundreds of hours a week for 15 years. Oil fields, railroading, truck driving,
Do
army.
you have family here locally?
Yeah, I stay away from here because everybody says that this place just drags you in a hole here. So I just bop in and
Well,
bop
my
out.
question is, do you have somebody here locally who could help you?
I don't have any way to get a hold of them. I have no numbers. I have nothing.
Okay. All right, well, make arrangements to get an attorney and that's what you need at this point. I can't, from where I'm sitting, I can't solve your problems at this point. You're gonna have to take that action, get a hold of somebody. It referenced in this affidavit is that as I understand it, suggests you have a father here locally.
Yes.
You're not in touch with him?
That's the one they're blaming me on assaulting, but I never assaulted him. He handed me the keys to try to get my truck fixed, and then my truck didn't get fixed, and so I was just like, I'm going home. He called me, and I said I'll be back tomorrow, and all I needed to do was either get a pole start or a couple batteries, and then just get it going until I get
Again,
the
I
truck
think
home.
Mr. Cooper's advice to you earlier is well based. Don't start here you're on the record right now. And anything you say, at this point, can be used against you. So let's just leave it at that. See if you can't get hold of somebody to get some help. All right?
Okay.